curious about why they need to do a will. Everyone should have a will. Currently about 40% of Australians do not have a will. That is about 2 out of every 5. When you don't have a will, you're leaving behind a headache and a lot of angst for your loved ones. It really is very easy to do a will. If you come to OShea and Dyer Solicitors to do a will, we hope that you can go away thinking, how easy was that? Why didn't I do it sooner? So what is the point of doing a will? There are lots of reasons and I'll go through them. Firstly, you need a will so you can appoint your executor. Perhaps the most important reason to do a will is to choose the person who will have the legal authority to finalise your affairs after you have died. This person is called your executor. When you pass, there will be lots of things that need to be sorted out. Bank accounts, superannuation funds, and property will need to be closed, finalised or transferred. Organisations like banks, super funds, nursing homes and so on will need to deal with a person who has the legal authority. They may not simply deal with your closest relative or best friend. Legal authority is best given in the form of a will that appoints an executor. Normally people appoint 1 or 2 people as their executor, though you can appoint up to 4 people. They'll make the decisions together to sort out your estate. Your executors can act alone to sort out or administer your estate, though sometimes executors engage a lawyer to assist them. If there is property to be transferred or the estate is substantial, it may be necessary to do this. Lawyers charge fees for the work they do. The fees are paid from your estate, or if the executors pay them, they will be reimbursed from the estate. Another important reason you need a will is so you can give instructions about how you want your estate to be distributed. This aspect of a will is best known. Who do you want to inherit your assets? Sometimes there is a straightforward answer to this, such as I leave everything to my partner, then after we have both passed, I want everything to go to our children. Or I leave cash gift to my best friend, and then the rest is left to my siblings in equal shares. There are countless variations to the usual scenarios. Every person has particular wishes and almost all of these can be put into a will. A will is also a means to appoint a guardian for your children. If you are the parent of a child under the age of 18, it is very important that your will nominates a person who would act as guardian of that child in the event that both parents have passed away. So what happens if you don't have a will? If there is no will, then there will be no certainty about any of these issues. Without a will, there is no clear direction about who has legal authority to sort out your estate. There is no clear statement about how your estate is to be divided. It's possible that someone will be forced to make an extensive application to the court for the appointment of an administrator. The court may even appoint someone to administer your estate who you have not chosen, for example a spouse from whom you have separated but not yet divorced. Once the administrator is appointed by the court, then that person will distribute the assets of the estate in accordance with the laws of intestacy. This provides an order of priority for the family members to receive the estate. Spouse, including ex-spouse in some cases, children of the deceased, then parents, siblings, nieces and nephews, grandparents, aunts and uncles. This may not be what you want, your assets to be shared after you have passed away. If you don't have a will, the law of intestacy must apply. How do I prepare for an appointment without making my will? Sometimes there are specific things that people need to discuss, but I'll go through them, the usual things that we talk about in your appointment. It's a good idea to have thought about them before you come in to see us. If you haven't, that's okay, as we will help you figure out what is best for your situation. These are things you'll probably need to think about. Who will be your executor? You can appoint more than one person. Think of a person who you trust completely, who is capable of administering your estate in the best interests of your beneficiaries. This is often your spouse, or 1 or 2 of your adult children, or your best friend. Think about the beneficiaries. This might simply be your spouse and or your children. But will you include stepchildren, estranged children or other relatives? If you're not married, you don't have children, who will you leave your estate to? Your parents or siblings or a friend? You may wish to leave it to a charity or 2. If your children are very young, it's possible that the children may inherit something from an estate while they are young. What age do you want your children to receive the money? 18, 21, 25 years? Who is to be the guardian of your children? We will discuss the contents of your estate. Your current assets and liabilities, including residential and investment property, family heirlooms and jewellery, shares in a private or public company, collections of any value, loans by you or to you. If you operate a business or have a family trust or company, we'll discuss the structure of these as well. We'll help to bring along copies of these business documents such as trust deeds and company extracts if you own assets in another country, or you think you might in the future. We'll discuss preparing a will that you can be recognised in that country. If you wish to make a gift to a charity, you should decide beforehand which organisation you wish to mention in your will. Superannuation funds, we recommend you bring along your most recent annual statements. And if you have a self-managed super fund, then we will need to look at those trust deeds, which set out the rules. If you have any life insurance policies, bring along the relevant paperwork. If you have previous wills, bring along copies of them as well. This sounds complicated, but having a lawyer makes all this easy for you. We also prepare an enduring power of attorney for you for free, and we'll discuss whether you need a superannuation binding death benefit nomination. Appointments can be made by phoning 0747 25 155 or going to our website, OSheaDyer.com.au, and starting your will online. There are many resources and lists on our website that are helpful. Come see us today.